Election.
May I have your lordship's permission to commence the proceedings of the court?
Yes, please. My conference. My esteemed brother and sister judges, learned Attorney General Shri R. Venkatramani, learned Solicitor General Shri Tushar Mehta, learned law officers, Shri Vikas Singh, President Supreme Court Bar Association, Shri Manoj Kumar Mishra, President Supreme Court Advocates on Record Association, members of the bar, family members of Shri Justice G.T. Nanavati, late Shri Justice S. Ranganathan, and late Shri Justice D.P. Mohapatra, who are present here and who have joined online, ladies and gentlemen. We have gathered this afternoon to remember and pay homage to Shri Justice G.T. Nanavati, Shri Justice S. Ranganathan, and Shri Justice D.P. Mohapatra, all three who had adorned the bench of this court. Shri Justice Girish Thakurlal Nanavati was born on 17th of February 1935. He hailed from a family of lawyers. His father, late Shri Thakurlal Nandkishore Das Nanavati, was an eminent lawyer of his times who practiced in the district court Bharuch. His grandfather and uncle too were in legal profession. He obtained his bachelor's degree in economics and politics from St. Xavier's College, Bombay, and in law from Government Law College, Bombay in the year 1956. He obtained his master's degrees in economics and politics from Bombay University in the year 1957 and in law in the year 1959. He enrolled as an advocate with the Bombay Bar Association in February 1958 and started his legal practice by joining the chambers of Shri H.M. Chokshi, senior advocate. Upon bifurcation of the erstwhile state of Bombay in the year 1960, he shifted base to Ahmedabad and initially started practicing on revenue side. However, very soon he started appearing in criminal cases as well. It is at this stage that his true potential came to be recognized. In the year 1964, he was appointed as an additional public prosecutor and assistant government pleader, which proved to be a watershed moment in his career. Acknowledging his merit, he was appointed as permanent judge of the High Court of Gujarat on 19th of July 1979. He became the acting Chief Justice of the High Court of Gujarat in the year 1992 for a short while and was the senior-most judge of the High Court of Gujarat till December 1993. He was the Vice Chairman of the Legal Aid Advisory Board of Gujarat State for 3 years, in which capacity the legal aid program in the state got a new boost. He also served as chairman under the Prevention of Anti-Social and National Security Act for 3 years from 1979. He was transferred to the High Court of Orissa on 14th of December 1993. He was appointed as the Chief Justice of the High Court of Orissa on 31st of January 1994 and was transferred to the High Court of Karnataka as the Chief Justice on 28th of September 1994. he was elevated to the Supreme Court on 6th of March 1995 and demitted the office on 16th of February 2000. During his tenure in the Supreme Court, he authored several landmark judgments, particularly in the field of criminal law, taxation, and service law. Some of his notable decisions were in Paschim Banga Khed Mazdoor Samiti versus State of West Bengal. The bench of Justice S.C. Agarwal and Justice G.T. Nanavati delivered a landmark judgment on the right to emergency health care and declared that the right to life enshrined in the Constitution of India imposes an obligation on the state to safeguard the right to life of every person and that preservation of human life is of paramount importance. It was further held that denial of timely medical treatment necessary to preserve human life in government-owned hospitals would be a violation of this right. In Air India versus Cochin International Airport Limited, His Lordship delineated the scope of judicial review in contractual matters. It was held that the scope of judicial review is confined to scrutiny of the decision-making process. The decision could be annulled only if it was vitiated by malafide arbitrariness or total unreasonableness. It was emphasized that judicial intervention would be warranted only when the overwhelming public interest so required. In Rashmi Kumar versus Mahesh Kumar Bhada, the bench of Justice K. Ramaswamy and Justice G.T. Nanavati observed that the Stridhan is the exclusive property of the wife. It was held that if the in-laws of the woman have dominion over the Stridhan and it is not returned to her despite demands, then a case for criminal breach of trust would be made out against the in-laws. In Sunil Fulchand Shah versus Union of India, he was part of a 5-judge bench of this court, which dealt with the reforms in the criminal justice system. It was inter alia held that the period of parole is to be counted as part of detention period. In J. Jayalalitha versus Union of India, wherein Ms. Jayalalitha and others had challenged appointment of 3 special judges for expedient disposal of cases against her on day-to-day basis, His Lordship held that even in the same area where a special judge has already been appointed, a necessity may arise for appointing one more special judge for dealing with a particular case or group of cases because of some special features of that case or cases for some other special reasons, and that there is no good reason to restrict the power of state government. In Consumer Education and Research Society versus Union of India, wherein the state of Gujarat faced challenges from petitioner society to its attempts to cut down the total area of Narayan Sarovar Chinkara Society, altering its boundaries by resolution passed by state legislature, His Lordship held that it would not be proper to question the decision of state legislature made under Section 26A of the Wildlife Protection Act unless there existed substantial and compelling grounds to do so. Even where the decision was found to have been taken hastily without due consideration of relevant aspects, it would not be prudent to quash the decision unless it was established that the decision would have an irreversible adverse effect on the wildlife and environment. In Bulla Das versus State of Bihar, wherein the High Court confirmed death sentence on the ground that the accused was a professional hired killer, His Lordship opined that there was no evidence on record on the basis of which it could have been held that the appellant was a professional killer having previous history of killing others on payment of money. Discarding this circumstance from consideration, he held that it was not a rarest of rare case and commuted death sentence to life imprisonment. He was also part of 9 judges constitution bench answering the presidential reference, special reference 1 of 1998 on questions of constitutional importance with regard to the appointment and transfer of judges. Subsequent to his retirement, he was requested by the Government of India to head a one-man commission of inquiry to inquire into the matter of assault on the lawyers near Parliament House, Delhi. He was also called upon by the Government of India to lead a one-man commission of inquiry for investigating the 1984 anti-Sikh riots following the assassination of the then Prime Minister Srimati Indira Gandhi on 8th of May 2000. And according to his report, the inability to summon the Indian forces on time was a civil administration blunder which caused huge rioting and casualties. He was also called upon by the government of Gujarat to lead the two-member commission as a chairman of Commission of Inquiry to probe into the burning of S6 coach of the Sabarmati Express, which is popularly known as 2002 Godhra Carnage and Aftermath Riots Commission, which took place in the state of Gujarat in the year 2000 on 21st of May 2002. The report of the commission threw light on many aspects of the matter. Apart from 1984 and 2002 riot probes in the year 2005, he also headed a commission of inquiry to probe into the regularization of unauthorized colonies in the NCT of Delhi. He was also nominated by the Government of India to the Permanent Court of Arbitration and actively conducted many domestic and international commercial arbitrations. He was well-read, amiable, courteous, and a firm judge. He never minced his words, both in his judgments as well as in his public speeches. He was known as a fearless judge who always upheld individual liberties. He was a strict and disciplinarian judge and one of the finest judges with quick grasp and elephantine memory. His quick reactions led the lawyers appearing before him to be fully prepared with the facts and law in their matters. Having said that, he was full of warmth and affection. He was truly an outstanding judge. Towards the end of his career, he moved away from the legal system and increasingly involved himself in philanthropic works. He always had inclination towards academics, and even during his busy practice, he did not ignore the academic pursuits and was a part-time lecturer in Sri L.A. Shah Law College and I. M. Nanavati Law College. He left for heavenly abode on 18th of December 2021 and is survived by his wife Sri Vanmala Nanavati, who is a lawyer by profession, his sons Sri Dhaval Nanavati and Sri Maulik Nanavati, who are practicing lawyers, and their families. Sri Justice Srinivasachar Ranganathan was born on 31st of October 1927. He obtained his BA Honours degree in mathematics from the Presidency College, Chennai in the year 1947. He further obtained his degree in law from the Law College, Madras in the year 1949. He joined the chambers of Sri C.S. Ramarao Sahib, who was an eminent standing counsel with the Commissioner of Income Tax at Chennai. The career and achievements of Justice Sri Ranganathan were extraordinary in every sense. He started his career as a legal practitioner on enrolling at the Madras Bar on 21st of July 1952 and continued to work as a junior lawyer with Sri C.S. Ramarao Sahib. Simultaneously, he also qualified for the postgraduate degree in law by private study and got the ML degree in law in the year 1953. On 1st of October 1954, he was appointed as the junior standing counsel to the Commissioner of Income Tax, Madras, and was subsequently appointed as senior standing counsel and worked as such till February 1964, where he played significant role in ensuring that the nation's need for revenue were attempted to be fulfilled fairly and honorably. In recognition of his distinguished contribution as a tax law practitioner, he was appointed as a judicial member of the Income Tax Appellate Tribunal, Calcutta on 24th of February 1964 and was confirmed with effect from 4th of August 1967. He was promoted as the Vice President of the Southern and Northern Zones of the Tribunal in the year 1975 and as its President in the year 1976, where he continued to demonstrate his remarkable scholarship and commitment to serving the ends of justice. He was appointed as an additional judge of the High Court of Delhi on 14th of November 1977 and as a permanent judge on 19th of March 1978. During his tenure in the High Court of Delhi, he delivered several erudite judgments in all branches of law, including criminal law. He also presided over the bench hearing the appeals preferred by the convicts in Srimati Indira Gandhi's assassination case. In the year 1987, he was elevated as a judge of the Supreme Court. During his tenure in the Supreme Court, he delivered many notable judgments such as Dwarkadas Marfati and Sons versus Court of Bombay, which related to the power of judicial review of actions of public authorities, Ujagar Prints versus Union of India, which related to the interpretation of Section 2 into bracket F of the Central Excise Act, the processes of bleaching, dyeing, printing, glazing, shrink proofing, etc., carried on in respect of cotton and man-made grey fabrics, which were held to be amounting to manufacture. In Escorts Limited versus Union of India, it was held that an amending provision which is given retrospective effect and is merely clarifying the position already existing is not open to challenge as imposing oppressive burden, as no new obligation was created thereunder. In A.R. Antule versus R.S. Naik, it was held that though the audi alteram partem rule is a basic requirement of the rule of law, but the degree of compliance with this rule and the extent of consequences flowing from failure to do so will vary from case to case. The rules of natural justice must not be stretched too far. They should be allowed to be exploited as a purely technical weapon to undo a decision which does not in reality cause substantial injustice and which, had the party been really aggrieved thereby, could have been set right by immediate action. The bench of Justice Sabyasachi Mukherjee, as the Honorable Chief Justice then was, and Justice Ranganathan, has to its credit many landmark decisions in commercial law and especially in arbitration field. He demitted office on 30th of October 1992. Post his retirement, he served as the member of the 13th Law Commission of India for 2 years. Thereafter, he was appointed as the first chairperson of the Authority for Advance Rulings, a quasi-judicial body created under the Income Tax Act 1961, and held that post until October 1997. He kept himself engaged with consultancy and arbitration work. He was associated with the revision of V.S. Sundaram's income tax for its 7th edition. He later revised A.C. Sampatha Iyengar's Law of Income Tax for its 7th and 8th editions. He also authored a book on corporate taxation in India. He delivered Sir Alladi Krishnaswamy Iyer Memorial Lecture on the Constitution of India, 5 decades, reviewing the amendments made in the Constitution between the years 1950 and 1999, which was brought out as a book in the year 1999. He did not limit his knowledge only to law, but had great interest in the epics and approached ancient texts with spiritual bent of mind. His scholarly interests were also in the field of literature, more particularly Sanskrit language. In the year 1999, under the auspices of Bharatiya Vidya Bhavan, a book on Meghadutam and Sri Hamsa Sandesam, a parallel study, a comparative translation in English of the works of two great Sanskrit poets, was published. In the year 2017, he also wrote a book on Sundarakandam of Srimad Valmiki Ramayanam. These literary works demonstrate the depth of Justice Ranganathan's ideas and the ease with which he was able to communicate sublime propositions. He also had an interest in Carnatic music. During his school days, he was recipient of Sundari Ammal Gold Medal, and during his college days, he was awarded the Junior Thomson Prize for proficiency in English and was the recipient of Lakshmi Narsa Reddy Gold Medal. He was also one of the recipients of National Citizens Award 1992 for his contribution to law and jurisprudence presented to him in the year 1994 by the then Vice President of India, Sri K.R. Narayanan at New Delhi. One of my sister judges of this court, Justice B.V. Nagaratna, in a tribute to Justice S. Ranganathan, shares that, quote, he will be fondly remembered for his unassuming demeanor and unmatched sagacity and simplicity. He had an astute legal mind whose keen thinking had been channelized towards redressing issues at every level, be it in aiding and encouraging the average citizen in resolving his everyday problems, or in seamlessly rendering judgments in the areas of constitutional law and law of taxation, among other spheres. His judgments were appropriate to the contemporaneous times. His orders and judgments are principle guided and relevant to this date. They can serve as sanctimonious texts for everyone in the legal field, whether a law student, a young lawyer, senior members of the bar, or even to the bench. He has attained judicial immortality not only for his several remarkable judicial pronouncements, but also for the principled approach he adopted in arriving at the same. Such principles have been reflected in one of his pronouncements, where he chose to differ with his own stance taken in a previous judgment by observing that consistency for the mere sake of it is no virtue, and that to perpetuate an error is no heroism. He was a personality of conviction, a person who shed all other considerations to take a stand for justice, to be served in a manner as he believed it to be served. He was a family man who enjoyed the company of friends and families. He had the ability to converse and interact with persons from all walks of life, and he made them feel comfortable and at ease. Unquote. He was indeed one such noble man in the truest sense, who with his liberality of thought and outlook, sturdy independence, total fairness, objectivity, impartiality, vigilance, and simplicity, left a rich legacy for us to abide by and seek to pursue. He left for heavenly abode on 20th of January of this year and is survived by his wife, Srimati Hemalata Ranganathan, daughters Miss Rupakala Ranganathan and Miss Deepamala Ranganathan, both of whom are qualified lawyers and company secretaries. Sri Justice Debapriya Mahapatra was born on 3rd of August 1937 into a family of eminent lawyers. His father, late Sri Justice Sauri Prasad Mahapatra, was a leading lawyer of his times who later became Judge of the High Court of Orissa. His Lordship did his graduation from Allahabad and read law at MS Law College, Cuttack. He enrolled himself as an advocate at the High Court of Orissa on 12th of October 1960. He handled a variety of important cases on the constitutional, civil, and criminal side in the High Court of Orissa and in the subordinate courts. He also served as the Additional Standing Counsel, Government of Orissa from August 1967 to February 1969, and as the Standing Counsel for Transport Department from March 1969 to February 1976. He was appointed as the Additional Government Advocate in March 1976, and lastly as Government Advocate before his elevation as a Judge of the High Court of Orissa. He was appointed as a Judge of the High Court of Orissa on 18th of November 1983. He held the office of the Acting Chief Justice of the High Court of Orissa from May 1995 to February 1996. He was appointed as the Chief Justice of the High Court of Allahabad on 16th of February 1996 and was elevated to the Supreme Court on 9th of December 1998. During his tenure, his notable decisions are: in Daniel Latifi, he was part of the Constitution bench that delivered a landmark judgment while interpreting the Hindu Minority and Guardianship Act and upholding the constitutional validity of the Muslim Women Protection of Right on Divorce Act 1986. In Abdul Karim versus State of Karnataka, he was part of the bench which directed the government to find sandalwood smuggler Veerappan and his associates who had kidnapped a Kannada film actor and his assistants. In ESP Rajaram versus Union of India, dealing with the controversy in an earlier decided case, that was Bhaskar's case, the bench held that pay scales admissible to all traffic apprentices appointed prior to the cut-off dates would not be confined to some individual employees or a section of employees. It was also held that hearing each individual concerned was not necessary for Supreme Court while exercising its powers under Article 142. In Kolhapur Cane Sugar Works Limited versus Union of India, which dealt with the repeal and deletion of a statute, his lordship held that repeal of a statute or deletion of a provision, unless covered by Section 6(1) of the General Clauses Act or a saving provision, totally obliterated it from the statute book, and the pending proceedings stand discontinued. In Mathuram Agarwal versus State of Madhya Pradesh, relating to the issue of municipal and property tax, his lordship held that there is no tax liability in law if there is ambiguity in the provisions as to any of the three components of tax law, that is, subject of tax, person who is liable to pay tax, and the rate at which tax is to be paid. In such circumstances, only the legislature can amend the provisions or repeal it and enact a new one. In Parveen Mehta versus Inderjit Mehta, dealing with the issue of divorce and mental cruelty, his lordship held that the mental cruelty is a state of mind and is therefore necessarily a matter of inference to be drawn from the facts and circumstances established by the evidence on record. Only then can the inference be drawn that the petitioner had been caused to suffer mental cruelty by the spouse. He demitted office on 2nd of August 2002. Justice Mohapatra was a great believer for maintaining the highest standards of personal integrity and demeanor in judicial conduct and had a liberal approach in the interpretation of law to meet the ends of social justice. He truly believed that the judiciary cannot exist without the trust and confidence of the people. He eschewed improper demeanor and engaging in personal behavior that would call judicial integrity into question. In his 20 years of illustrious judgeship, he left an indelible impression as a humanist and a rationalist judge in the course of dispensation of justice. His conviction in the rule of law and judicial wisdom, humility and ambient personality earned the respect and admiration of the entire legal fraternity. Subsequent to his retirement, he was appointed as the first chairperson of the Odisha Human Rights Commission in July 2003, which post he held till August 2007. He was a devoted family man and a mentor to many. He left for heavenly abode on 31st of August of this year and is survived by his wife Srimati Manju Mohapatra, daughters Srimati Pushpa Mishra, Srimati Mitra Kabi and Srimati Smita Rath and their families. I had the personal privilege of appearing before all three learned judges, and I share great moments of practice before them. I learned a lot from them, and that's something which is a personal treasure for me. My brother and sister judges join me in conveying our heartfelt condolences to the bereaved families, and we pray to the Almighty to give them strength to bear this irreparable loss with fortitude. May the departed souls rest in peace.
Honorable the Chief Justice of India, Honorable Judges of the Supreme Court, the Solicitor General of India, Additional Solicitor General, President in Office Bar of the Supreme Court Bar Association, President in Office Bar of the Supreme Court Advocacy and Record Association, members of the Bar, ladies and gentlemen. You are assembled here today to pay homage to late Mr. Justice G.T. Nanavati, late Mr. Justice S. Ranganathan, and late Mr. Justice Devapriya Mohapatra, former judges of the Supreme Court of India. Born in a family of lawyers, Justice Girish Thakurlal Nanavati, in a remote village in Jambusara, Bharuch district, state of Gujarat, it is probably preordained that he will enter the legal profession in due course. Graduating from prestigious St. Xavier's College in Mumbai and enrolling in Government Law College in Mumbai to receive his bachelor's and master's degree in law. Launching his professional career in 1958 in the High Court of Bombay, Justice Nanavati shifted his practice to Ahmedabad. In the year 1964, Justice Nanavati was appointed as a public prosecutor, which was then a coveted appointment made for the High Court and remained as such till he was appointed as permanent judge of the High Court of Gujarat in July 1979. Justice Nanavati served as Chief Justice of the High Court of Orissa and Chief Justice of the High Court of Karnataka, and fondly remembered by the members of the bar in both High Courts. Justice Nanavati served as court for a good period of 5 years from March 1995 till February 2000. Credit goes to him for having been on the bench with utmost attention, with an ear for details, alert ever to picking up new ideas and perceptions. The Honorable Chief Justice has referred to some of the notable judgments delivered by Justice Nanavati. Each one of them reflect the engagement of deep understanding, creativity, and interpretative dynamics, and what is known as the common law growth. Particularly, Paschim Bangal's case has laid a firm foundation for the right to emergency health care and the right to health in general. After retirement, Justice Nanavati was called upon to lead several commissions of inquiries in Delhi, in Godhra, and I find that the reports given by him are a rich veritable contribution to public law reports. And Justice Nanavati, as it is also nominated to the Permanent Court of Arbitration and continuing with arbitration matters from all over India. Toward the end of his career, Justice Nanavati moved away from the legal system and involved himself in philanthropic work. Justice Nanavati is survived by his wife, Srimati Bana Nanavati, his two sons, Mr. Dawal Nanavati and Ms. Nolit Nanavati, daughter-in-law Sajini Nanavati, and grandson Arav. Mr. Dawal Nanavati is eldest and a practicing lawyer in Gujarat High Court and in Supreme Court. And Ms. Nolit Nanavati is younger son, earlier practiced in Supreme Court and settled in Ahmedabad. On my behalf and members of the bar, I express my heartfelt condolences to all his family members and friends. May Almighty bless his departed soul to rest in peace. Ranganathan was born in 1927 in a family of great learning and scholars hailing from Tanjore district in Tamil Nadu. A gold medalist in SSLC, he bagged the prestigious Lakshmi Narasa Reddy Gold Medal in Government Law College, Madras. He had rigorous training in the chambers of C.S. Ramarao after enduring as an advocate in the High Court in 1952, and Mr. Ramarao was an eminent standing counsel in the Income Tax Department. This Ranganathan's equipment as a tax lawyer earned him his position as junior standing counsel and subsequently as senior standing counsel, and later on as a member of the Income Tax Appellate Tribunal. He spent almost 10 good years in the bench of the Delhi High Court from 1977. His judgments in Seth Banaras Das Gupta versus Commissioner of Income Tax in 1978 and Devan Izzat Rai versus Devan Iqbal Ratnanda in 1980 on the question of territorial jurisdiction of the High Courts have held the field and are often cited. His erudition and logically impeccable partial dissent in Antule is a treat along with the powerful dissent of Judge M. Venkatachalaya. Ujgar Prince is remembered for making the distinction between processing and manufacture, where the test of emergence of a new commodity has been cited many hundred times. In Orissa Cement Limited State of Orissa, the Ranganathan entirely held the distinction between tax on land and tax and income arising from land, and observed that with respect to the Orissa Cess Act 1962, the legislation intended the same to be applicable in royalty rather than with respect to land. Therefore, the levy was unsustainable. In the Federation of Mining Assets Rajasthan, the state of Rajasthan, with respect to Rajasthan Land Tax Act 1985, it was observed that tax and annual value of mineral-bearing land based on dead rent royalty, whichever is higher, held suffers from legislative incompetence. The court went on to observe that it is not possible to sever the invalid portion with the tax based on royalty, so as to declare the remaining portion of the act invalid. Also, it affirmed the state legislature did not have the competence to legislate for the levy of tax on mineral-bearing lands based on the royalty derived from the land. On the bench in the lane petrochemicals, he endorsed the view the fundamental right of press cannot be snatched away merely on the grounds of apprehension of harm. In the Delhi Stock Exchange Association case, the court held the stock exchange derives income from properties held under trust. After demitting office, he was associated with the revision of P.S. Sundaram works on income tax and Sampath Iyengar's law of income tax, which preciously occupy the chambers of almost every tax lawyer. A scholar in Sanskrit, in 1999, he completed his work on Magadhidam and Sriham's Sandesam, a parallel study which is a comprehensive translation of the works of two most prolific Sanskrit poets. I must say that while he was doing this undertaking work, I was often called to do some editing job, and I did it with a great amount of enjoyment. In 2017, he also wrote a book on Sundar Khan for the Srimad Valmiki Ramayana. He is survived by his wife Srimati Hemalata and his twin daughters Rupkala and Deepmala. Both of them are qualified lawyers and company secretaries. His sad demise has created a void, just not for his family and friends, but for the entire legal fraternity at large. The footprints which Ranganathan has left in the shifting sand of time will continue to help us, guide us, and inspire us in future years. Justice Mohapatra commenced his practice before the Orissa High Court on 12th of October 1960 and has studied 23 years of reputed practice in civil, criminal, and constitutional law. And serving as additional standing counsel from 1967 until 1976, he had served the government in various capacities. And in 1980, he was served as the government advocate prior to the elevation of Judge of the Orissa High Court on 18 November 1983, and he was acting Chief Justice of Orissa High Court between May 1995 February 1996. Appointed thereafter Chief Justice of Allahabad High Court on 15 February 1996. He was sworn in as the Judge of the Supreme Court of India on 9 December 1998 after his superannuation from Supreme Court on 3 August 2002. He was appointed as first chairperson of the Orissa Human Rights Commission in July 2003. Recollecting my position as an amicus curiae in the National Human Rights Commission, Justice Mohapatra had often called me to work with him in the Orissa Human Rights Commission on an honorary basis. I value that engagement very seriously. He continued as a judge of the High Court, and during his tenure as judge of the Supreme Court of India, Justice Mohapatra had authored several landmark judgments in the field of constitutional law, criminal law, intellectual property rights, and taxation laws. In Mathuram Agarwal, the learned judge held that it is not the economic results sought to be obtained in the taxing statute which is relevant in interpreting a fiscal statute. Daniel Latavi, a milestone in personal laws, he was part of the constitution bill that upheld the constitutional validity of the Muslim Protection of Right and Diverse Act and paved the way for a seminal debate on personal law reform. In Abdul Karim, Justice Mohapatra was a part of the Supreme Court bench delicately but firmly handled the job of dealing with the exploits of Sandwood Mangala Veerappan and his associates and rescued a kidnapped Kannada film actor and his assistant. Justice Mohapatra has left his mark in judicial history as a thoughtful, wise, and compassionate judge. His belief in rule of law, his humility and affable personality has earned the respect and admiration of the entire legal fraternity. Justice Mohapatra is survived by his wife, 3 daughters, and 4 grandchildren. I express my heartfelt condolences to the members of the bereaved family and pray that the departed noble soul of Justice Dev Prema Patra rest in peace.
Justice U. Lalit, Honorable Chief Justice of India, Honorable Judges of this Court, Shri R. Venkat Ramani, Learned Attorney General for India, law officers, members of the family of late Justice G.T. Nanavati, members of the family of late Justice S. Raghunathan, and members of the family of late Justice Deva Priya Mahapatra, members of the Executive Committee of SCBA, Manoj Mishra, President SCORA, members of the Executive Committee of SCORA, members of the bar, ladies and gentlemen. We have gathered here today to pay our respects to 3 stalwarts of the Indian judiciary, for whom no tribute, no matter how rich and deeply felt, is enough. I nevertheless hope that I can do justice to their memory through these words. I had the privilege to regularly appear before all these honorable judges, and my memory of them was that they were of impeccable integrity and of great intellect. Small towns in Gujarat have a tendency to give this fortunate country some of its most celebrated sons and daughters. One such accomplished son of Gujarat was Justice Nanavati, who was born in the tiny hamlet of Jamsubad in Bharuch district of Gujarat. His father was himself a renowned lawyer who graced the halls of the district court of Bharuch. His grandfather and uncle were both lawyers as well. Being the eldest of the 12 children, it must have seemed like natural progression when he eventually chose to enter the field of law himself. Even at the young age that he had all the promise of a future jurist and decided to follow his LLB with a MA in Economics and Politics from Bombay University and then finally LLM in the year 1959. Justice Nanavati enrolled as an advocate in the Bombay Bar Association in February 1958. It was Bombay's bad luck and Ahmedabad's great fortune that he shifted to the latter city after the erstwhile state of Bombay was bifurcated in 1960. Although he had initially started his practice dealing with revenue matters, he found his true calling in criminal cases. In 1964, he was appointed as the additional public prosecutor and the assistant government pleader. He was a formidable prosecutor for any accused to have encountered in a criminal trial. The constitutional scheme necessitates that judiciary should fearlessly hold the executive account, but his role in checking executive excesses would not end with his stint as Honorable Judge of the Supreme Court. It is a measure of his integrity and the faith that the government had in his abilities that he was asked to unravel the truth behind 2 of the independent India's most tragic events, that is the 1984 and the 2002 riots. His unrelenting pursuit of truth helped shed light on the events that led to these riots. His report even today are a lesson that we would always remember. Justice Nanavati was appointed as a commission to probe the regularization of unauthorized colonies in the National Capital Territory of Delhi, a complex challenge that he took on with great ease and dedication. Justice Nanavati was also nominated by the Government of India to the Permanent Court of Arbitration. Justice Nanavati decided a large number of arbitration matters and was involved in the same till his very end. Once a person reaches a certain stature, his legacy is not merely of himself and his kith and kin, and belongs instead to all who follow his footsteps. Having said that, I have no doubt in my mind that his legacy is safe in the hands of his family, his wife, Srimati Vanmala Nanavati, who is a lawyer herself, his two sons, Dhaval and Maulik Nanavati, and his daughter-in-law, Sajana Nanavati. I had the distinct pleasure of mentoring Dhaval when he started his practice, and it gives me great joy to see him emerge as a formidable lawyer in his own right. Justice Ranganathan was born in 1927 in the city of Madras. He did his schooling from the PS High School. He subsequently enrolled at the famous Residency College Madras and finally earned his legal education at the Government Law College Madras. He enrolled in the bar and began a successful career in the field of taxation. In a mere 2 years after he began his practice in 1954, he was appointed as the Standing Counsel for the Income Tax Department. It is a testament to his legal prowess that he was considered a doyen of taxation law in a city like Madras, which had given the country some of its finest minds in the field. A decade later, he was appointed as a judicial member of the Income Tax Appellate Tribunal. He was subsequently elevated as a judge of the Delhi High Court in 77, where he would go on to serve till 1987, in which year he found himself appointed to the Supreme Court. He went on to serve this court with distinction until his retirement in the year 1992. As a judge, Justice Ranganathan brought to his pronouncements an erudition and clarity that conformed to the highest traditions of the Indian judiciary. He is reputed to have done his own extensive research before deciding matters before him. His orders were unfailingly on the point. He never used a sentence when a word would suffice, but did not shy away from elucidating upon his views where it was warranted. It is this quality of his that makes his judgments a pleasure to read, even years after his retirement as a judge. Through his judgments, one is treated to a veritable journey of the statutory provision through his entire history. His commitment to justice was such that he is known to have even decided cases based upon points that weren't argued before him, despite being relevant to the issue at hand. Despite his command over law, he was always encouraging to young lawyers appearing before him, guiding them gently and encouraging them to put forth their case with confidence and without hesitation. After his retirement from the Supreme Court, he was appointed to the Law Commission, where he made several significant recommendations. He was also the first chairman of the Advanced Authority for Advanced Ruling until 1997, after which he chose to retire. Justice Ranganathan chose to spend his free time indulging in his love for Sanskrit. He is survived by his wife and two twin daughters. Justice Devapriya Mahapatra was born on 3rd of August 37 in Odisha, was the son of an accomplished jurist of the Odisha High Court, Justice S.P. Mahapatra. He did his schooling from the historical Revenue Collegiate School, Cuttack. After securing a degree in Madras Christian College, he went ahead with another degree at the Ewing Christian College, Allahabad, and then finally secured his legal degree from the Madhusudan Law College, Cuttack. He was involved as an advocate in the Odisha bar in 1916 and thus began a career in law that would span 23 years, and he practiced in civil, criminal and constitutional law. His illustrious career at the bar came to an end when he accepted an offer to adorn the bench of the Odisha High Court in 1983. In 1996, he was sent to the Allahabad High Court as its Chief Justice, and in 1998, he was elevated to the Supreme Court and retired in August of 2002. Throughout his judicial career, he exemplified the best virtues of a judge. He is known to have given every lawyer a patient and a very kind hearing, and left every lawyer who argued before him with the satisfaction that he had been given a fair opportunity to present his case. He brought to the bench the knowledge and varied experience with every branch of law. Many of us lawyers who had appeared before Justice Mahapatra can never fail to recall his remarkable quality of having an open mind about the case till the very end. In the aftermath of his death, glowing tributes poured in from every quarter about the sort of human being Justice Mahapatra was. The law was devoid of humanity, is no law worth preserving, and the same is true of those who were tasked with the onerous responsibility of enforcing and interpreting it. Justice Mahapatra was not merely a scholar par excellence, but also a very good human being. It is no surprise then that when the Odisha government was looking for a suitable candidate to help the affairs of the newly created Odisha Human Rights Commission, it chose Justice Mahapatra. In him, the institution found an able steward, and it is a testament to his abilities as a jurist and as a leader that it now functions as an effective tool to ensure that most of the cherished values of our constitution are preserved and observed to their fullest measure. Justice Mahapatra was a devoted family man and a mentor to many. Justice Mahapatra is survived by his wife, 3 daughters, and 4 grandchildren. I, on behalf of the Supreme Court Bar Association, offer our condolences on behalf of the entire bar to the members of the family of late Shri G.T. Nanavati, late Justice S. Ranganathan, and late Justice Devapriya Mahapatra. May their souls rest in divine peace.
May I request you all to stand up and observe 2 minutes silence in the memory of departed souls.
May I have your lordship's permission to conclude the proceedings of the court?
Yes, please.